Hi, everyone, and welcome to today's webinar. My name is Stacy Sattung with the Housing Alliance of Pennsylvania. Thanks for joining us. Our webinar today is titled The CDC Eviction Moratorium, Protecting Renters from Eviction. To let you know, this presentation is being recorded and will run approximately 60 minutes, including question and answer time. Additionally, please note that any information shared in the chat will be saved. We will also send you a link to this presentation today via email and the recording later on this week, as well as uploading it to our YouTube channel and our website. Attendees will be muted during the presentation. If you have questions for the presenters, please type them in the Q&A box at the bottom of your screen. If you have a logistical question for myself and other Housing Alliance staff, please use the chat feature. The chat feature should not be used for questions for the presenters. Please use the Q&A for questions. I'll now turn it over to Gale Schwartz to begin today's presentation.
Thank you, Stacy, and thank you to everybody who has joined us for today's webinar. I'm going to share my screen real quick. For those of you who don't know me, my name is Gale Schwartz. I'm the Associate Director of Policy and Strategic Initiatives here at the Housing Alliance. To go over our agenda for today's webinar, we're going to do some quick level setting, understanding eviction filings that are happening right now in Pennsylvania. Then we're going to have a really great panel discussion with folks from the legal services community. So I welcome Rachel Garland from Community Legal Services, Dan Vitek from Community Justice Project, and Matt Rich from Mid Penn Legal Services. And then we're going to round out the conversation with a presentation on assistance for renters that can be accessed through the Pennsylvania Attorney General's office. And with that, we have Jess Harvey, who works in the Bureau of Consumer Protection within the Attorney General's office. So I do just want to say before we get into the meat of today's presentation that as with all things COVID related, we are really working in a rapidly changing landscape. The information that is being provided today is the best information that we have today, and it could change in the weeks and the months ahead. The information provided today should not be taken as legal advice. And if you or someone you know is actively facing an eviction situation and needs legal advice on whether the CDC moratorium covers their specific situation, we recommend that you reach out to legal services or contact the County Bar Association in your community. So with that, I do want to take some time just so that we can understand eviction filings in Pennsylvania. We know that a moratorium was issued by Governor Wolf last summer, and that these moratoriums, while not perfect, were generally effective at greatly reducing the spread of COVID. Pennsylvania was not the only state to have issued a moratorium. Many states across the country issued moratoriums, and that really allowed researchers to evaluate the effectiveness, specifically when it comes to the spread of COVID-19. And so there were two pretty profound studies that came out of Duke University, as well as a collaboration from Johns Hopkins, the University of California, and Boston University, that really showed that, again, these moratoriums were effective at preventing the spread of COVID-19. Specifically, the Duke researchers found that policies limiting evictions reduced COVID-19 infections by 3.8% and deaths by 11%. Compared to what would have happened if nothing had been done. And again, researchers from Johns Hopkins and the University of California and others also compared the numbers in the 27 states where state level moratoriums had ended with the 17 states that had kept them in place. And we're able to estimate that lifting moratoriums resulted in the average of over 430,000 cases and more than 10,000 deaths. So again, when thinking about this unprecedented public health crisis, moratoriums really were necessary in spreading infection and saving lives. So starting to think about, what is happening with evictions in Pennsylvania specifically, we've been looking at the data. And this is, a graph that was put into a brief that we released earlier this month, and we'll be sure to email out again to folks after today's webinar, really talking about how moratoriums are affecting eviction filings in Pennsylvania. So looking at, the early or the last summer into the early part of fall, we can see that, with the state moratorium, which was, far more comprehensive than the CDC moratorium, it was really, really effective at stopping filings from happening. And then the way things played out, we saw that we had a few days lag between when the state moratorium ended and the CDC moratorium picked up. And in that amount of time, we saw a huge surge in filings that took place. And then once the moratorium came into place, we saw the numbers draw back down. So really what ended up happening is that the Pennsylvania moratorium averaged about 268 filings per week were still happening. In that window where there was no moratoriums or protections, we saw a surge of over 3,600 filings happen. And then once the CDC moratorium came back in place, we've been averaging just shy of 1,300 filings weekly across the state of Pennsylvania. So one thing that is important to clarify is that unlike the state moratorium, which prevented all landlords from filing evictions, the CDC moratorium does require renters to take proactive steps, which our panel will speak to in a bit, and it does not stop the court process from going forward. We also know by looking at the data that we have a better sense of, who is really facing housing instability in Pennsylvania. This is looking at the U.S. Census Household Pulse Survey. We know that, as recent as early March, there was a significant number of renter households in Pennsylvania, over 350,000, that are just not confident that they're going to be able to make rent next month. We also know that while on average 25% of renter households don't feel like they have much confidence in making next month's rent, when you break it out by racial demographics, we start to see a pretty significant disproportionate impact on Black, Latino, and households that identify as others, such as Indigenous or multiracial, biracial. And then we also know that eviction doesn't always neatly correlate with poverty, right? So as we look at the history of eviction prior to COVID-19, we see counties with the highest eviction filings are not necessarily the counties that have the highest poverty rate. But we do see that they are counties that have some of the most significant proportion of non-white households in Pennsylvania. So again, this is just sort of a snapshot of eviction in the COVID-19 context, and who is really bearing the brunt of eviction filings and is most vulnerable. So with that, I want to turn it over. I'm going to stop sharing my screen, and I want to get to the better part of this presentation, which is the panel discussion with our amazing legal experts. So my first question is going to be directed towards Dan. And if you could please just tell us, what is the CDC order?
Okay, thank you. Thanks for that data. It's always jarring to see what is happening on the ground in your day-to-day life in numbers like that. All right, so the Center for Disease Control eviction ban or eviction moratorium, the CDC order, there's lots of names going around for what it is. And essentially what it is that the Federal Centers for Disease Control has issued a nationwide order that, in a nutshell, says it is illegal for a landlord to evict a qualified tenant for non-payment of rent or for a non-fault of the tenant until the order expires. And that order, okay, is enforceable throughout the country, and it is based on the CDC's authority to try to mitigate the health effects of COVID-19 and other diseases, right? So looking at that a little bit more specifically, this order applies to all residential properties in Pennsylvania. So that's apartments, single-family homes, mobile home parks, rooming houses. It does not apply to, say, a motel or a hotel, that short-term stay that is not your permanent address. The order was set to expire initially last year at the end of December 2020, but it's been extended a few times. It currently runs through the end of June. There is the potential for it to be extended either by statute or by the CDC itself for longer, but right now it runs until the end of June. But I don't want anybody to think that this is a true eviction ban or an absolute ban on evictions. It's not. It does require that the tenant be qualified in order for the protections to apply. So for the protections to apply, for the tenant to become qualified, they must meet certain qualifications that I'll discuss in just a little bit. They must self-certify that they meet those qualifications. And this is what we call the CDC Declaration. You might have heard that term being thrown around a lot. Essentially, the Center for Disease Control, in its order, proposed a declaration that lays out all the qualifications a tenant must have to meet, and the tenant can sign that declaration. Okay, the tenant doesn't have to use the CDC's version of the declaration, but must use a similar form and must self-certify under penalty of perjury. And then, and this is critical, they have to provide that self-certification, that declaration form, to the landlord. So they have to meet the qualifications. They have to certify that they meet those qualifications under penalty of perjury, and they have to provide the landlord with that certification or declaration, right? Then the tenant becomes qualified and is protected from eviction for non-payment of rent or other non-fault reasons. So what are those qualifications? First, income-based, right? But a pretty high level. As an individual tenant, you have to make less than $99,000 a year. If you're so if you're married, then that's basically double. So pretty high bar, but you can't be super rich. Okay. Then the tenant cannot be able to afford to pay their full rent. That's pretty self-explanatory. You can't make the rent. Now, the reason you can't make the rent has to be related to an income loss. Note that I didn't say it has to be related to COVID-19. It just has to be related to a loss of income, which could be caused by any number of factors. Now, That means that it doesn't apply to people who are on fixed incomes like SSI or retirement benefits if they're not losing any income, unless they have large medical bills, something like that. So they have to make less than $99,000. They can't afford the rent because they have lost income. Then the tenant has to be making their best effort to pay the rent. It's kind of a strange qualification, but you can't afford to pay the full rent, but you have to be making best effort to pay. So it doesn't, just because you've lost income, if you still have the income to pay for your rent, then you have to be doing that. But that's, of course, mixed in with all the other expenses that one has for their necessities in life. Shelter isn't the only necessity in life. And then the tenant has to make an attempt at getting government benefits to assist in paying the rent. That's a pretty open-ended question, right? That they have to be making efforts, best efforts to qualify for help from the government. Obviously, there's some rent help programs out there specifically because of COVID-19. There's other programs generally. The tenant doesn't have to qualify for them, but they have to be at least trying to get those. They can't be ignoring any means to help them pay the rent. And then finally, the tenant has to be facing homelessness or a situation where they would be crowded with others, doubling up with a family or friends, going to a shelter. So in other words, if they can't find their own apartment that matches what they had before, they're putting themselves and others at risk of contracting COVID-19. And so that's the qualification. Just to run through that again, got to be income qualified. Can't be able to afford your rent because you lost income, but you're making your best effort to pay. You're attempting to get government benefits. And if you're evicted, you would be homeless or you would be forced to move someplace where you might be exposed to COVID-19 because of the other people that you'd be living with. If these are all true, if the tenant qualifies, tenant self-certifies, and provides that documentation to the landlord, that is what triggers the order to make it illegal for the landlord to pursue eviction for non-payment of rent or no fault of the tenant. After that, it doesn't matter if the eviction has already started or the eviction is going to start. It becomes illegal to remove the tenant from the home. Now, enforcement is fairly straightforward in one sense. A landlord could be prosecuted by the Department of Justice for violating this federal order from the CDC. There is potential jail time, but large fines that could come with that. But also, the courts are looking at this and saying, we're not going to allow landlords who have to pursue judicial process in order to evict to do something that's illegal. So the courts are putting, making sure that they're not allowing evictions to go forward that would be illegal under this order. And then, of course, tenants have the right to raise their protections under this order as a defense in any eviction proceeding. So that's really how this order is being enforced. Highlights again, it's a federal court order from it's a federal order from the CDC that applies to qualified tenants. They have to take those steps to get themselves qualified, and then once they do, it becomes illegal to evict for non-payment of rent or non-fault of the tenant.
Great, thank you. My next question is to Rachel from CLS. And what is this CDC really trying to achieve?
So the CDC, what's really interesting and was somewhat unexpected for those of us that are practitioners when this came out in September, is the CDC is the Federal Center for Disease Control. So they are coming at this purely from a public health priority. And in the fall, with the concern that there was going to be a second spike in infections, the CDC was really considering what the overall public health of the country was and whether that would be served by displacement, either through eviction or through the need for tenants to go out and look for places to move and for landlords to, hold open houses and be showing their units to new tenants with the hope of them moving in. And the CDC decided that they had the authority, in the interest of the country's public health, to try and limit the amount of moves and evictions that were happening at that time, based on the scientific evidence that they had. So because it was a public health response, it was a very measured one, and that they were really only going to take it on a short-term basis based on what was happening with the virus nationally, which is why it's only being extended generally for 1 or 2 months at a time. So initially, it came out in September. It's been extended pretty much monthly since then. The most recent extension is now through June 30th. I do think at this point, in addition to it being a public health concern, there's also some recognition that the federal government just awarded or allocated $25 billion in rental assistance across the country around the same time that the most recent CDC order was going to expire. And so the timing of that was problematic. And so I think part of the concern was there are many landlords that are hurting right now financially. They haven't received rent in many months. There's many tenants that are hurting financially right now and are facing eviction because of not being able to pay rent. And there's $25 billion that could go to supporting those tenants and landlords. And so let's give the virus a little bit of time to go down. We're seeing nationally that even though almost half of all adults have received their first vaccine, the numbers are still continuing to rise in terms of infections. So we are clearly not out of the pandemic yet. We are clearly not clear of a public health disaster yet. And in the meantime, there's money that can really stabilize landlords and tenants. So the extension of the CDC moratorium through June 30th is really an attempt to make sure that there is time for the country to vaccinate as many people as possible, and there is time for this money to flow into the hands of landlords and tenants.
Excellent, thank you. And my next question is for Matt from Mid Penn Legal. How does a tenant really gain protection under the moratorium?
Yeah, thanks, Gale. And if you're able, either you or if Stacy's still on, if you can share the form so that I can have everyone who's participating check out what we're talking about. So when we talk about the declaration forms, and as Dan had mentioned earlier, right? So the key point as to where the CDC order and moratorium differs from the prior moratoriums, either by the Supreme Court's orders shutting down the courts, or the governor's moratorium, or the CARES Act, if we think all the way back to March of last year, which seems so long ago now. Those just automatically applied to covered individuals, whereas with the CDC order and moratorium, as Dana mentioned, again, it's a requirement that the tenant provide this declaration to his or her landlord. So we have one here. Gale, if you're able to kind of scale or to skim down here. This is the CDC's version, which can be found on their website. I know Rachel had put a link to it in the chat. And you'll see here, for any of those who are familiar with the prior forms, it was more of it didn't have check boxes, although it was just a kind of a statement, a veriment by a veriment or paragraph by paragraph, where you had to ultimately sign off that all of the statements were true and correct. Now I think they've done a good job of cleaning up the declaration form. There's still a bit of a confusion here, but it's pretty user friendly. If you take a look through there, you're looking at column A, again, with the issues that Dana mentioned earlier, that one of the key points is proving that you made $99,000 or less in 2020 or 2021. And here they've also expanded that a little bit to you can check off to see if you maybe you don't know exactly what your income was. If you received a stimulus check, it's going to apply. If you weren't required to report any income to the IRS in 2020, it'll apply. And then also there's a notation there that if you're eligible for public assistance benefits, SNAP and TANF, or if you receive Social Security, whether it's SSI or SSDI, that you're likely to be eligible and qualify. And if you aren't able to check off any of those boxes, then you can't continue the inquiry. You're not going to qualify. You're not going to be able to avail yourself of the protections of the order. If you get to column B, then again, Dana hit on this earlier, cannot pay a full rent or make a full housing payment, and you have to explain why. And that could be usually tied to a loss of income. It can also be as a result of extraordinary out-of-pocket medical expenses. Now, When it comes to loss of income, there's no technical definition that's outlined there, but with out-of-pocket medical expenses, they do actually define it. I don't know, Gale, if you're able to scale down to the footnote there. It's actually defined as 7.5% of a person's, sorry, it's at the bottom of page 1, yeah, their adjusted gross income for the year. And then beyond that, on the second page here, the declaration shows that they qualify because their income level meets, because they've done the best to make their timely payments, that they would become homeless but for the protections of the order. And then also there's some notations of understanding there, which we'll talk a little bit more about later too. But so, and if you can, Gale, also the AOPC, the Administrative Office of Pennsylvania Courts, has adopted essentially the CDC's declaration form onto, you know, the format used by the court system. So the CDC declaration itself, if you go to the CDC site, that's what we recommend individuals to utilize if there is no current case pending in the court system. Whereas if there is a current case pending, if a landlord's already filed, or if there's already been a hearing or a judgment entered, and the tenant is then trying to issue the declaration at that point, we tend to have them utilize the AOPC form so that they can note the actual case that they are referencing. The big deal here for the CDC declaration is that it must be provided to the landlord. So kind of the interesting discussion that we've had in the tenant community is with regard to what the court's role is exactly in enforcing the CDC order and declarations. The big deal from the tenant's advocate's perspective is that the tenant has to be advised of the need to serve it to his or her landlord. That is what essentially kicks in the protections. And this is, the order itself is really aimed at the landlord, right? Making sure that the landlord is aware that once they receive this declaration, that they're not to take any further steps to pursue eviction of the tenant at that point. So I saw some questions in the chat on this already. What do we do then? What are we advising tenants to do with regard to the declaration form? So once it's completed, one point of caution here is that I know early on we had some concerns that, you know, these declarations were making their way around communities, either through like tenants advocacy groups or what have you, and there wasn't a lot of context being provided. I mean, as Dan mentioned earlier, that we're very cognizant of that, you know, tenants are signing this under penalty of perjury. So what is concerning is that if tenants get their hands on this and they view this as simply, hey, this is the way to stop my landlord from being able to evict me, all I have to do is sign this form, check off some boxes, and that'll prevent me from being evicted. They have to understand that there are potential consequences if they can't meet all of the declarations that are contained herein. So I think to the extent that anybody who's listening here will be working with tenants on this, it should be made known to the tenant exactly what it is that they're checking and what it is that they're signing off on before they provide it to the landlord. But once they provide it to their landlord, what we've suggested is to essentially use as many means as possible to provide it to the landlord and to garner proof that it has indeed been provided. So, I mean, obviously personal service is great to the extent that you're able to verify that through some sort of evidence, if you have a witness handy, or if you can get the landlord to sign off on a receipt. We've also advised tenants to send it by electronic mail, by email, if they're able. That's imperfect, but at least creates a record of having provided the email to the landlord and having attached the signed declaration to the email via fax, if anybody's, to the extent anybody's using fax machines anymore, certified mail with a return receipt. By whatever means possible to, number one, get the declaration to the landlord, and then number two, provide the tenant with any and all proof that the declaration was indeed provided to the landlord. And I will say this is a bit of a tricky topic to get into. I don't want to take too much time. I know Rachel had touched on a little bit in one of the comments that there are some protections provided to tenants by local court systems as far as what landlords are able to ask of the tenant as far as the declaration is concerned. For instance, here in Dauphin County, we have an order from our president judge that says that once the declaration's been provided, that the court system's really to play no role whatsoever in determining necessarily whether the tenant is being truthful on their declaration or what have you. That differs from county to county. But as far as actually serving it to the landlord, the hope is that in the vast majority of circumstances that it won't require too much in the way of proof from the tenant. What we've been advising tenants to do to really close the loop on the situation, assuming that there is a case pending in court, is to, once they have provided it to their landlord, to then also notify the court through whatever means. There isn't necessarily a form in particular, but to notify the court through whatever means that they have indeed provided it to their landlord, and to provide whatever evidence they have that they provided it to their landlord, with the hope that the court then will, even if the landlord tries to pursue the eviction thereafter, that the court will then put a stop or a freeze on proceedings at that point. So that's all I have on that, Gale, for the moment. I'll come back and try to answer some questions. I know we'll come back to talk more about this shortly.
Excellent. Thank you. And so my next question is for Dan. There are certain rights for tenants under the state law. So how does this moratorium impact those rights?
So I'll try to be real quick because I want to make sure we get on to the rest of the presentation. I think the first thing that comes to mind is a tenant's right to a habitable home, right? A safe place to live. It's called the implied warranty of habitability. That's a legal term for it. And it says that, when you rent a residential property to a tenant, doesn't matter what the lease says, it's the landlord's responsibility to make sure that that is safe and sanitary for the tenant to use. In other words, if the tenant didn't break it, the landlord has to fix it. And one of the tenant's rights when the landlord doesn't fix it after they've been told of the problem and given a chance to repair it is to withhold their rent. It's a fairly common remedy that tenants will use to make sure the landlord makes the repair. And of course, this order says that the tenant is making best efforts to pay their rent. So maybe there's a little bit of a tricky situation there where the tenant is experiencing issues that aren't being repaired, causing the place to not be a great place to live, but they also don't have the income to pay the full rent, so they want the protections of the CDC order to prevent an eviction. My recommendation is just go ahead and complete the declaration if you're the tenant, explaining that you've lost income, that you can't pay the full rent, and that you are making your best efforts and looking for government assistance, etc. And then also continue to tell the landlord in writing that they need to make these repairs and and do your best to enforce your right. Your right to a habitable home as a tenant isn't going away. It's just that you might already you might be kind of, one of your remedies might be a problem if you can't afford the rent, or if you're required to make your best effort to pay the rent. Another right that might be a little tricky with this is if you are sued for eviction, and you initially go to the magisterial district court. If you don't like the decision there as a tenant, you can appeal, right? Any party can appeal to the Court of Common Pleas. If the tenant appeals, they have to pay their rent into escrow with the court in order to stay in their home while the appeal is processed, which can be several months. If the tenant is trying to appeal, right, but then they don't have the income and they want to be able to get the protections of the CDC order, that should apply. They should still have the right to appeal and stay in their place as long as they provide the landlord with the declaration. The landlord is not allowed to evict because of non-payment into that escrow account. And the tenant in that situation should also provide the declaration to the court. So it has to provide it to the landlord, should also provide it to the court, so the court understands why there would be a deficiency in that account. But I do warn everybody, if you're advising a tenant in this situation, really in any of these situations where they're the tenant is taking advantage of the declaration to prevent an eviction when they can't pay the rent, the rent is still due, so there's going to be a significant problem if they can't catch up on the rent by the time the order expires. And that would be the same thing for a tenant who's on appeal. Those are the two main things that I think come up when you talk about Pennsylvania tenant rights and the CDC order.
Great, thank you. I think those are two big issues as repairs and damages and those type of issues continue to come up, whether people are able to pay rent or not. My next question is for Rachel. This is now the third time the CDC moratorium has extended. We've even seen some pretty substantive changes to the form itself. Are declaration forms that were signed back in September still valid, or do new ones need to be signed?
Yes, they're still valid. Most of the changes that have happened in the form are either stylistic or an attempt to make them more easily understandable, but the main points of what the tenant is declaring under perjury are still the same. Sometimes they have checkboxes, sometimes they're just bullet points for you to sign at the end. If you've provided your landlord with any form, or if you're a landlord and you've received any version of this form since it came out in September, that is still acceptable. It doesn't matter the expiration date at the top. It's just when they issued the form, they put the expiration date of the order that was in place at that time. But because the order is extended, it's not like one order ended and then they entered a new order. It's the same order that they're just continuing to extend. So those declaration forms are still in effect. If you just Google, if you don't have a link to the form and you just Google CDC Eviction Moratorium, any of the top PDFs that come up are fine for you to use and send out.
Great, great. And I know that there have also been some other organizations that have developed templates like the National Low Income Housing Coalition and other places, and all of those forms, as long as they contain the same basic information, they are valid as well.
Yes, and I also will note, to piggyback on what Rachel had said, that the newest version of the form actually has a footnote that indicates that every prior form is still valid and that the tenant does not necessarily have to reissue the declaration.
Excellent, excellent. And Dan touched on this a little bit, but I just want to round out the conversation again. And the final question will go to you, Matt. Are tenants still financially responsible for the rent owed?
Yes, so with any of the moratoriums that we've seen thus far, at least here locally anyway, there's been no rent cancellation as part of the moratoriums, and not with the CDC moratorium either. So this is quite literally a kicking the can down the road type situation as far as rent itself is concerned. So although evictions are not allowed to commence, the rent is still going to be owed when it's all said and done. The bill will come due. And so this is, I will try to loop this back in then to what Rachel had mentioned earlier about the substantial rental assistance that's been made available here in the recent last month or so, and the emergency rental assistance and emergency rental or utility assistance programs that have been made available statewide, and also in certain counties you may have had your own particular county programs, but the statewide program's been up and running for a little over a month now. And so that's a whole different discussion for maybe that could be its own, and I think is part of, or the topic of, many other training sessions. So I won't spend too much time on it here today, but realistically, when we're talking about this moratorium, as has been mentioned, is meant to be coupled with the notion of utilizing rental assistance to try to alleviate the debts that tenants owe, so that we can avoid this potential tsunami of evictions. So to the extent that you are working with a landlord or a tenant, because even though it's, we think of rental assistance as being a tenant's benefit program, but under these circumstances, it's just as much a landlord benefit program as it is a tenant benefit program, and that it can help landlords recoup, most or potentially all of what's been owed to them through these trying times. So that's my last pin on that. But yes, the rent is still going to be owed. Rental assistance is our white knight to try to help alleviate those concerns, if at all possible.
Excellent, excellent. And anybody who needs to find rental assistance in their county, you can go to the DHS Compass website. it will either provide you a link to the application for your county or provide you the information for those counties who are running their programs directly. So that is the best place to refer for more information. And we can send some follow-up information after today's webinar that also talks more about how to find rental assistance in your community. Now that we've finished that great discussion, and I want to say thank you to the amazing panel that we just had, I do want to turn it over to sort of you're in a rental situation, you have created or you have proposed a declaration or presented the declaration, you're covered under it, and you're still having trouble with the landlord, they're still trying to evict you, they may even engage in what's called a self-help eviction and lock you out of your apartment. So with that, and Rachel had mentioned this earlier, there was some additional information provided timed with the update of the CDC moratorium that also asked some federal agencies to up their enforcement of the CDC moratorium or protections for those who are covered by the CDC moratorium. And recently this week, as I said, things are always developing. The Consumer Finance Protection Bureau did release some information related to that issue. So I want to introduce Jess Harvey, who can talk a little bit more about what the Consumer Finance Protection Bureau announced and how that would work in this context.
Thank you for having me. It's a pleasure to be able to talk to folks. Let me put that on the back burner just for a sec, Gale, and just give a little bit of an overview of what our office does with regard to landlord-tenant matters and generally kind of who we are and how we kind of have a seat at the table. So I'm going to start off by giving everybody our phone number. It's 800-441-2555. And we can be reached at attorneygeneral.gov. That's attorneygeneral, one word, .gov. There's no reference to PA for some reason. We must have been the first ones to get one of these email addresses. But that's how to get a hold of us generally. And I'll tell you, pre-COVID, I think when you would call, you would be connected immediately or almost immediately to a live person. Now you leave a message and we will get back to you on the day you call, as long as you call us before 4:30. But you will get a human contacting you back if you have an issue. And generally everybody's kind of trained to kind of talk with folks and direct them in the right place for any number of consumer issues, not just landlord tenant. And so what is the BCP? What is Bureau of Consumer Protection? Again, this is part of the AG's office. What do we do generally? We have two primary functions. We mediate consumer complaints. It's an informal mediation process. And I hope that some folks have maybe recommended or referred folks to our office. It's a relatively informal mediation process related to standard home improvement. Standard consumer matters like home improvement, car sales, anything like that, whatever, scams, what have you. And so we take those complaints and we try to resolve them, try to get money back for people. The other primary function is litigation / investigation. And so a number of laws in Pennsylvania protect consumers. Our bread and butter is the Unfair Trade the Pennsylvania Unfair Trade Practices and Consumer Protection Act. It gives us the ability to go in and seek injunctive relief, to seek restitution for folks, and to seek civil penalties. It's not a criminal statute, it's a civil statute. But we can run in in some instances seek injunctive relief, or we can contact the business, try to get money back for people and sign a settlement agreement of some sort. And kind of connecting in with the Unfair Trade Practices Act are a number of different statutes: the Home Improvement Consumer Protection Act, state auto regs, the Fair Credit Extension Uniformity Act, which is akin to the Federal Fair Debt Collection Practices Act, and some other statutes. That's just a couple of them. So where do we fit in with regard to kind of housing issues? Well, there's a number of them, but I'll tell you that, you know, we're there with Mobile Home Community Rights Act. That provides us with some ins. We deal with habitability issues as well. When we see a landlord and a number of tenants impacted, we will argue that their failure to keep the place habitable is a violation of the Unfair Trade Practices Act. And then we're seeing security deposit issues. We have a couple statutes, a couple lawsuits up in the State College area dealing with security deposit abuses, where the landlords are withholding administrative fees, and the withholding from the security deposit is not for actual damages to the rental property. So we're, you know, engaged there as well. And, you know, like I said, the Manufactured Community Housing Act, we've taken a couple legal actions with regard to park closures and getting people back the value of their homes as a result of closure. So that's everything that's not kind of, you know, necessarily landlord tenant. But with regard to landlord tenant, what we do is what I call triage lockout cases. So when somebody calls our office and says that they've been locked out from their home, from their rental property, those become priority matters within the office as soon as we get the message right now, or as soon as somebody would call. We do not require that person to file a written complaint. We have the ability to take a written complaint. If you visit our website, you could see that one of the boxes that pops right up is file a complaint. You can do that electronically. You can do it old school by sending a letter. But with regard to the landlord-tenant lockout situations, when we're, like, again, triaging these, we have people, we take a written complaint. I mean, we'll transcribe the complaint, and it'll get assigned to an agent who will talk to that landlord, talk to that tenant, and try to get the background information as best as they can. And then the agent will relay that information to an attorney. So, you know, hopefully we're getting information about what exactly is the situation. What was the lockout? Did they, you know, take a door off? Did they shut the utilities off? You know, change the locks, whatever. And frankly, the attorney, and that's been me and other attorneys here, just try to take the ball and run with it then. We are calling the landlord, usually that day, and advocating for them to let the person back in. We are not, and I guess I need to make this clear, we are not representing the tenant individually. We are not running into court and representing the tenant and filing an action or something against the landlord. We are trying to do this relatively informally, but, you know, persistently, and trying to get the landlord to kind of do this the right way, to go into the local district justice and file appropriately, and let the tenant back in the meantime. By and large, that's been relatively successful. We can't claim 100% success, but, you know, we feel that, you know, we've been pretty good in the results that we've been able to obtain. And, you know, what's our hook there? Our hook is going back to debt collection. We enforce the Pennsylvania Fair Credit Extension Uniformity Act, which I mentioned. That is akin to the Federal Debt Collection Practices Act. Except FCUA, the Pennsylvania version, also applies to creditors. So creditors are your landlords. And under FCUA, I just read the particular provisions that it prohibits. It prohibits it's a violation to take or threaten any non-judicial action to affect dispossession of property. Further, FACUA prohibits a creditor from threatening to take any legal action that can't legally be taken. So we enforce FACUA. A violation of FACUA is, under FACUA, a violation of the Unfair Trade Practices Act. It brings into, it allows us then to, potentially seek civil penalties, the injunctive relief, and restitution against creditors, in this case, landlords. So that's our hook. If a landlord tells us, what are you calling me for? What do you have to do with this? That's what we're talking to them about. We're saying, hey, listen, this has repercussions for you. And again, it is a relatively informal process, but a lot of times it works. Last summer, it seemed to heat up a lot. We did a lot of these phone calls all year. And of course, during COVID, we're apprising them of these moratoriums as well. We are, at the end of the day, we are kind of hopeful that the judicial system is working. We're not the U.S. Attorney's Office that is enforcing the CDC moratorium. We're the state AG's office. But we're certainly making landlords aware of the moratoriums that exist out there. I know there's been some landlord tenant actions that have kind of gotten through. I know that CMU's done some good work there as far as finding out, which landlords have nevertheless managed to kind of get through the moratorium and still file in violation of it. And we have had, I will say, a little bit of contact with the U.S. Attorney's Office out here, somewhat preliminarily about CDC, about enforcement of the CDC moratorium. More of a reporting kind of what we see to them. Getting back to your original thing about kind of hot off the presses. Yes, the CFPB, I think just yesterday, or maybe the day before, has issued an interim final rule under the debt, I guess it's under the debt collection regs, federal debt collection regs, that specifically notes that a debt collector may not falsely represent or imply to a consumer that the consumer is ineligible for temporary protection from eviction under the CDC order. So that's a violation of debt collection regs. The Fair Debt Collection Practices Act. And then also, and perhaps more importantly, it indicates that before filing an eviction action for non-payment of rent against a consumer, a debt collector must disclose that the consumer may be eligible for temporary protection from eviction under the CDC order. So that link that I had provided you earlier, Gale, indicates some disclosure language actually that should be utilized by the debt collectors. I will tell you that, if you page down there, but I will tell you that in practice, this is literally just hot off the presses. It becomes effective May 3rd, I believe. I have a little bit of a concern about its application, candidly. We're kind of digesting it here. Again, I think we got it yesterday or the day before, but it applies to debt collectors, not creditors. And the Fair Debt Collection Practices Act, the Federal Fair Debt Collection Practices Act, applies to debt collectors, not creditors. However, I keep mentioning FACUA, the Pennsylvania parallel statute. FACUA states that a violation of the Federal Fair Debt Collection Practices Act also violates the FACUA. So there's a little bit of an in there for us, but again, it would apply to debt collectors, not necessarily creditors / landlords. So, obviously we'll look at any tools we have when we're encountering these situations, but I wonder about how that'll work in practice. So anyway, I mean, kind of run through this relatively quickly, but again, I'll give you our phone number again. It's 800-441-2555. And our email address is attorneygeneral.gov. And if you run into some of these crisis situations where there's lockouts, particularly, we'll do the best we can. And sometimes a lot of times that's end up in a good result where people are then complying with the law. And anyway, and I see Dan here, and I kind of remember, I don't know if he'll recall, but we were on the phone with somebody the day before Thanksgiving last year, trying to get the water back on. So anyway, so we work with those guys too, and we're hopeful to, benefit as many people as we can. So we're a resource, and if you have questions, you can always reach out to us.
All right, so we have a minute left, and I think that there's one question that I want to pose to everybody who presented today, which the presentation today was absolutely amazing, and I think you really presented everything in a very clear way. The moratorium, it covers certain people in certain contexts. It really is a tool that's meant to be paired with rental assistance, and we are seeing more guidance and enforcement happening. Now, we have been hearing from different parts of the state that sometimes judges are not really acknowledging this order in court, and what is an action that a tenant can take, or somebody supporting a tenant who feels like the judge is not acting fairly or acknowledging in acknowledging this declaration. Is there any actions or process for them to take in that situation?
Yes, Gale, I think, kind of one caveat to pretty much everything that we've been talking about today is that to the extent that you're working with an individual who runs into a problem at any point in this process, is to reach out to the local legal aid organization in whatever county in which you reside. There is a legal aid office that covers every county in Pennsylvania. It may be a different organization. I mean, as you see, between Dan and Rachel and I, we're all working with different organizations throughout the state. And so I know that you can either, if you like, Google legal aid in whatever county. Also, I will pull up the Pennsylvania Legal Aid Network is the kind of umbrella organization oversees all of the legal aid services throughout the state of Pennsylvania by and large. So on their website, they have a directory as well, which I'll pull a link to and put in the chat for everyone if you need to locate the legal aid office in your area.
Excellent, excellent. Thank you so much. We are at the end of our hour. I know people have been asking many questions, and our amazing panelist here has been also answering those questions, but maybe we can download that Q&A chat and share that with our follow-up materials. This is an ongoing, continuing conversation. New details are emerging. We're continuing to work with the legal services community, the State Attorney General's office, to continue to share all of the best information with all of you as it comes available. We do have some other webinars coming up. We have a two-part high-level overview of housing law in Pennsylvania that is going to be coming up May 5th and 12th with Kadeem Morris from Community Legal Services. And then in June, on June 10th, please save the date, we are also going to be having another special event on eviction prevention kind of town hall that we will be hosting as well. So again, thank you all for being on today's webinar and for your great questions and for the great answers and information provided by the panel. Thank you, and we will see you next time.